Good evening and welcome to the 2025 F.R. Scott Lecture presented by the McGill Friends of the Libraries. My name is Stephanie Taylor and I am the Chair of Events of the McGill Friends of the Libraries, a volunteer group of local and international committed McGill Libraries advocates. We would like to acknowledge that McGill University is situated on land which has long served as a site of meeting and exchange amongst Indigenous peoples, including the Haudenosaunee and Anishinaabe nations. We acknowledge and thank the diverse Indigenous peoples whose presence marks this territory on which peoples of the world now gather. Founded in 1989, the mission of the Friends of the Libraries is to develop community interest in the libraries, build awareness about their rich and diverse collections, and promote initiatives to create long-term support for the libraries. We share our passion for the libraries and the advancement of learning and knowledge by hosting 3 free annual public lectures. The first is the Shakespeare Lecture in partnership with the Stratford Festival, which was held just last week here in the Moot Court and featured Paul Yaknin, the Tomlinson Professor of Shakespeare Studies at McGill, Anthony Cimolino, the Artistic Director of the Stratford Festival, and Laurette Dubé, an Emerita Professor of the Des Hôtels Faculty of Management at McGill. And we held a discussion on how Shakespeare can help us accelerate the convergence between money-making and meaning-making in our modern world. The second lecture that we hold is the Hugh MacLennan Lecture in honor of the internationally acclaimed Canadian author and in partnership with Blue Metropolis Literary Festival. And our third lecture is tonight's F.R. Scott Lecture in honor of the Canadian lawyer, poet, intellectual, and constitutional scholar. J'aimerais remercier l'équipe multimédia à McGill, l'équipe de la bibliothèque, la faculté de droit et l'avancement universitaire pour leur aide dans l'organisation de cet événement ce soir. I would like to now welcome Lenore Harris, our brilliant and wonderful chair of the McGill Friends of the Libraries, who will introduce our incredible and inspiring speakers for this evening's F.R. Scott Lecture.
Ladies and gentlemen, esteemed guests, good evening and welcome to the 2025 McGill University Friends of the Libraries F.R. Scott Lecture. My name is Lenore Harris and I'm Chair of Friends of the Libraries. Please join me in extending a warm welcome to Justice Michelle O'Bonsawin this evening. We are privileged to have the opportunity to engage with a legal luminary whose wisdom, experience and commitment in upholding the principles of justice, fairness, and equality inspire us to strive for a more just and equitable society. I would like to acknowledge the presence of the Acting Dean of Faculty of Law, Tina Piper, who has recently assumed the position as the former Dean, Robert Leckie, was appointed a judge of the Superior Court of Quebec. How exciting and fulfilling for him. He has played an integral role in tonight's program. I would also like to recognize the presence of Justice Dominique Launay of the Court of Quebec. Welcome. And last but not least, I would like to extend from our Trenholm Dean, Guylaine Baudroy, her regrets for unable to be with us at the last minute. The F.R. Scott Lecture was established in 1989 to honor the memory and stellar career of Francis Reginald Scott, an eminent constitutional lawyer, poet, author, intellect, and politician. Scott won Canada's coveted literary prize, the Governor-General Award, twice, once for nonfiction for his essays on the Constitution, and once for poetry for his collected poems. He held the distinction of being a student, professor, and dean, all at McGill School of Law. His passion for human rights was underlined by his being a founding member of the first Canadian Social Democratic Party, the Cooperative Commonwealth Federation, and its successor, the New Democratic Party. Tonight's program has been graciously supported by Victoria Lamb, Peter McNally, and Charles Taylor. Our heartfelt thanks and appreciation to each of you. I now have the privilege of introducing our moderator for the evening, McGill University Professor Colleen Shepherd. Colleen, come. Colleen is the F.R. Scott Chair in Constitutional and Public Law and the Associate Dean of Graduate Studies here at the Law Faculty, a former director of the Montreal Centre for Human Rights and Legal Pluralism. She studied law at the University of Toronto and Harvard University. She was also a law clerk for Chief Justice Brian Dixon in the early days of the Charter. She's a member of the Law Society of Ontario and a fellow of the Royal Society of Canada. Associate Dean Shepherd's teaching and research focus on human rights, especially equality rights and anti-discrimination law, as well as legal research methodology and feminist theory. She has published extensively in these fields, most notably her book on inclusive equality in 2010, and her most recent book, Discrimination Stories, Exclusion, Law, and Everyday Life in 2021. In addition to her teaching and research, she has been active in public interest work. She served as a commissioner on the Quebec Human Rights and Youth Rights Commission in the 1990s and has done consulting work with numerous public institutions, including Justice Canada, the National Judicial Institute, the Canadian Human Rights Commission, the Truth and Reconciliation Commission of Canada, and the International Labour Organization. Colleen, thank you for the ease and efficiency you have displayed in stepping up to take Robert Lecky's place as moderator this evening. The stage is now yours.
You're in the seat now. OK. Merci, Lenore Harris. Et bonsoir, mesdames et messieurs. C'est un grand honneur de vous présenter l'Honorable Michelle O'Bonsawin, juge de la Cour suprême du Canada. And it's really been a pleasure to be able to step in for Dean Lecky since his appointment to the Quebec Superior Court and be engaged in this conversation with the Justice this evening. Justice O'Bonsawin's career is defined by groundbreaking achievements and a steadfast commitment to advancing a more equitable and accessible legal system for all Canadians. An Abenaki member of the Odanak First Nation, Justice O'Bonsawin grew up in a small Francophone town close to Sudbury, Ontario. In May 2017, she made history as the first Indigenous judge appointed to the Ontario Superior Court of Justice in Ottawa. Then again, in September 2022, she made history once again as the first Indigenous judge appointed to the Supreme Court of Canada, marking a significant step forward towards a more inclusive and diverse judiciary. Le juge O'Bonsawin est titulaire d'un baccalauréat en droit de l'Université d'Ottawa, d'une maîtrise en droit dans le domaine de la santé mentale de la faculté de droit Osgood Hall et d'un doctorat en droit de l'Université d'Ottawa. Ses études doctorales se sont concentrées sur l'utilisation des principes GLADU qui guident le système juridique pour mieux tenir compte de la situation des individus autochtones. Le juge O'Bonsawin a également reçu des doctorats honorifiques de l'Université Bishop et de l'Université Laurentienne. Prior to becoming a judge, Justice O'Bonsawin had a distinguished public career in the public sector institutions. She began with the Royal Canadian Mounted Police Legal Services and was then counsel with Canada Post. She specialized in both those organizations in labor and employment law and in privacy law. She then became general counsel at the Royal Ottawa Healthcare Group, which allowed her to develop special expertise in issues relating to mental health. And we're going to be talking about some of these themes in our conversation tonight. A passionate educator and mentor, Justice O'Bonsawin has taught Indigenous law at the University of Ottawa, led the Indigenous Relations Program at the Royal Ottawa Healthcare Group, and mentored Indigenous law students, women law students, and lawyers. Her career exemplifies a tireless dedication to mental health advocacy, Indigenous rights, and access to justice. This evening, I'm honored to engage in a conversation with Justice O'Bonsawin about her life and work in law. So with that, I'll move into the other little chair, and we're going to have about a 35-minute exchange of questions and conversation, and then we'll open it up for the audience. Et vous êtes bienvenus de poser des questions après la conversation, soit en anglais ou en français, parce que Madame la juge, évidemment, est parfaitement bilingue. OK. Microphones are working?
Yes.
Yes?
I think so. Yes.
Okay. So, in putting together some questions, and I'm really excited to be a bit of a journalist tonight, I divided our conversation up into three sort of periods. Justice O'Bonsawin's early years and formative years in her life that led her to the path she took. The legal work and issues which she engaged with prior to being named to the Supreme Court of Canada, and then some of the current issues and challenges with her work on the court. So I think we'll start with the first sort of set of questions, and one is simply really what led you to pursue a career in law, and how and did your experiences and background as an Abenaki woman from a small Francophone community in Ontario shape your career choices? So I really want to learn about you. Yes.
I'll just start off by introducing myself in my language as per our tradition. So, Nadeliwizi Michelle O'Bonsawin, Nadzawi Odanak, Wabanakik, Alnoba, Taplawinonia, Udoza, Richard Tadian. So, as you know, I am Michelle O'Bonsawin, a proud member of Odanak First Nation, a Turtle Clan Society member, and the daughter of Richard and Diane. So with that, it's really funny. I get asked this question, why did you go into law? And I have to say, I do come from a blue-collar background. There are no professionals in my family. My father, all my uncles, they all worked at International Nickel Company or either Falconbridge, because for those of you that know, Sudbury is known as a mining town. My mother was a teacher. So for some reason, when I was 9 years old, I told my parents I was going to be a lawyer. So I don't know if it was something I saw on TV, but whatever it was, I had decided that I was going to pursue a career in law. And I was really fortunate because coming from people who are blue-collar workers, I was really fortunate that my family thought that anything was possible and really helped me pursue my dream of one day becoming a lawyer. So I find that I'm really, really fortunate to have had that support, because it's not every kid who tells their parents at 9, I'm going to be a lawyer, and their parents say, hey, you could do it, even though you come from where you come.
Yeah, and in terms of the Francophone community, did you go to French schools when you were?
I did. So I pursued the majority of my schooling in French. So at home, my first language is French. So I went to school up until university. I went to Laurentian University, did my studies in French, and then I went to l'Université d'Ottawa, le programme de common law français, where I did my French common law program. And then afterwards, I pursued my other post-secondary studies in English. So, but the majority of my studies have all been in French.
Interesting. And just one other on your upbringing, because I know the Odanak First Nation is located in Quebec. And in terms of your connection as you were growing up with that community, how did that work, being in
So Odanak is
Ontario?
quite the distance from Sudbury. It's about an hour from here off of Highway 30 on the way towards Sorel, Quebec. As a child, we would actually go to Odanak once every little while to visit my dad's cousins, etc. I have to say that it was a transition because as a child, my father faced a lot of discrimination. There are 8 children in his family. When they were young, they were called the Little Savages of Sunnybury, which is the street that they grew up on. So my father, as a child, had a difficult situation along with his brothers and sisters. So I think that there was that hesitancy as he was growing up because of that discrimination they faced. And then when my generation arrived, I think that's where they did have more of a reconnection. Because as a child, he did go to Odanak, but I think a lot of the teachings weren't passed on throughout his generation. It really happened in my generation where we really, les liens se sont tissés. So there was a close-knit relationship that reoccurred because of that. And I think there was the discrimination, but also the distance. And it's been a true joy for me moving to Ottawa because it has rendered me much closer to my First Nation, so I get to go back quite often. I was there a couple of weeks ago, so it's a nice little drive of 3.5 hours, and I'm fortunate to be so close now.
Yeah, okay, really interesting. And the other question I had about your sort of youth was what were some, and you've almost begun to speak about that, talking about your father, but what were some of the challenges or pivotal moments or experience that you had that have now shaped you as a jurist?
Well, I have to say, the challenges for me weren't as being a young Indigenous person. It was more being a Francophone growing up as a minority. So in Northern Ontario, it's very Francophone. About, back then, 30% of the population in the Sudbury area is French. I grew up in Hanmer, a little French town just outside. So when you think Sudbury as the main hub, all the little surrounding towns, Hanmer, Val-Caron, Val-Thérèse, Chelmsford, Azilda, all these little French towns surround it. So it was more important as a Franco-Ontarian to maintain our language. And that was more of an issue because when you're growing up, contrary what you see in Quebec, we're a minority outside of Quebec, and it's really important. And for me, growing up was really important to maintain my French language and to pass that on to my children. So when I went somewhere as a youth, my parents thought it was quite exceptional. I always spoke to wherever I went in French first, and if they didn't understand me, then I would switch to English, but I always asked to be served in French first.
Interesting, okay. And so you obviously then went university, pursued legal studies, and I wanted you to talk a bit about some of your work prior to becoming a judge as a lawyer. So, and maybe some of your studies as well, because interestingly, you went back to do your doctoral studies after having practiced law for,
Right.
Yeah, so
I, as you heard, started off my career at the RCMP Legal Services. I had been there in my 3rd year of law. And when I started practicing, I have to say there weren't a ton of positions at the time. I thought that I was going to work in Aboriginal law. That was my passion. But I have to be honest and tell you, I didn't get the dream job that I hoped to get. I had applied at a specific firm that did a lot of Aboriginal law. And it's funny, I saw the managing partner lately, and I said, see, you should have taken me. But I didn't get that dream job. And it led me to then go into a career, and I always tell people that I mentor, although you have an idea of where you're going, at times it doesn't always work out, and you got to be able to get up, dust yourself off, and pivot. So I started off at the RCMP Legal Services, and a little story is I had left that environment to actually join a private law firm. And once I and it was a funny period of time because I had an interview at the law firm. I also had an interview set up in a few weeks from then to go to Canada Post Corporation. And when I went to sign the contract at the law firm, they told me there was a little book on the counter, and I told the office manager, I said, hey, what's this book about golf? And I said, I love to golf. And he said, well, it's to wine and dine clients, etc. And I said, well, my husband, I'm hoping he'd like to learn to golf. And my husband I met in law school is an IP lawyer. And he was at a separate firm, and he asked me, what does your husband do? And I said, oh, he's an IP at this firm. And they said, oh, well, we have a huge file against them. So make sure that you tell the managing partner. So I meet the managing partner after meeting all these new supposed colleagues. And he tells me, oh, Michelle, don't worry about it. I know you have good ethics. You're a newbie. You've been hired to work on this specific file. Your husband's a newbie. Ain't going to be touching that file. So a couple of days later, I get a call from the managing partner telling me that they were nullifying my contract. So I had left a secure position at the RCMP to become a litigator, which was something that I wanted to do because I didn't want to do more solicitor work. I ended up by having kept that interview at Canada Post, thankfully. And I have to tell you, I did sue them, and I was successful in my case.
Oh.
But I ended up by successfully getting that position at Canada Post Corporation. And at first, when they hired me, they said, well, you're going to be doing corporate commercial work. And I thought, geez, I just left the RCMP because I didn't want to do solicitor work, but I thought I would take it and look for an alternative later on if I didn't like it. But the day before I started, the associate general counsel called and he said, hey, what do you think about doing labor law? And I said, well, I have to tell you, I didn't take labor law in school, but is it litigation? And he said, yes, it is. And I said, I'm your girl. So I ended up by having great mentorship when I started at Canada Post. And it was an amazing time because I was able to travel from west to east, see all of our country, doing labor employment, a lot of privacy work, human rights, access to information. And then afterwards, I had been there for a period of about 9 years. I had negotiated on a team of a couple of collective agreements. I was on the verge of having to do Cup W. Cup W, for those of you who don't know, it's one of the largest unions in Canada, represented at the time about 60,000 employees that they went on strike just before Christmas. So if you didn't get your parcels, it was because of that. But I was scheduled to go on this next tour of negotiating, and when you went into these negotiations for collective agreements, you'd disappear for a period of 2 years. Your family didn't see you. I had 2 young sons, and these negotiations, just to give you an idea, they're so long that I had time the second round I did for the postmasters to actually become pregnant, have a baby, and the round was still not done. So I had thought I can't disappear for a period, a couple of years. Back then, the Ontario reports would publish. So before everything was online, we'd get a little book every month. And I saw the job at the Royal Ottawa Healthcare Group. They were looking for a labor lawyer. And because I had specialized for a period of 9 years in that, they wanted someone with that specialty because a mental health institution has a lot of unions. There were 3 in Ottawa, 2 in our hospital in Brockville. So I started there in 2009 to create the legal department as general counsel. So I litigated myself all of the labor files. I did the employment matters, and then I became a specialist in mental health law, and I farmed out the corporate commercial work. So that gives you an idea. And so when I was at the Royal, it's a teaching hospital, has a close relationship with the University of Ottawa. And my clients were a lot of psychiatrists who specialize in forensic mental health law. And for those of you that don't know what that is, forensic mental health law is what I call more of a parallel system to our typical criminal justice system. So when a judge will find someone not criminally responsible or unfit to stand trial, they don't go through the regular criminal justice system in a jail setting. They go to a forensic mental health center like the Royal Ottawa here in Montreal. There's l'Institut Pinel, for example. So they go in a separate system, and there's a separate board and a judicial body that reviews all the conditions on a yearly basis for these individuals. And I had decided that I wanted to pursue a lot of research on treatment orders, and there was an interesting program in health law at Osgood Hall. So as I was working full-time as a litigator and managing all the legal work, I decided to do a part-time program to do a master's degree. It was a 24-month program, but I've never been known to stick around for that long. I thought I could do it faster, so I finished it in 18 months. And then I ended up in 2014 or 15, I joined the board at the University of Ottawa. And I thought it would be an opportune time to consider doing my PhD research because I had a developing interest in Gladue principles, which I'll explain what that is in a moment. But one of the perks of being on the board at the university is you get to have free education. So I thought this is a perfect time then to do my PhD. So in September 2016, I started my coursework. So I continued litigating and managing the practice, but I also continued doing the coursework until April of 2017. And I ended up by getting named to the court, the Superior Court, in May of 2017. So I took a 2-year hiatus to really focus on being a trial judge because it is an adjustment going from being a litigator to then be a judge in the Superior Court. And in my 3rd year on the court, I decided to go back to the PhD program. So I always say I was a judge by day, and on weekends and late at night, I was a PhD student for a period of 3 years. So finished all the different steps, and in December of 2021, successfully defended my PhD thesis. And it is, I'll just say quickly, what Gladue principles are. These are sentencing
This is
principles.
easy. You're making my job easy.
Sorry, I could just keep talking here. Gladue principles are sentencing principles that judges have to take into account for an Indigenous accused. So in 1995-96, the Government of Canada ended up by amending the Criminal Code to add this particular provision that the Supreme Court of Canada a couple years later ended up by interpreting about the obligation of trial judges to take into consideration the particular background of an Indigenous accused when looking at making a fit sentence for that person. And when I was at the Royal, as I was explaining to you, the forensic mental health system falls under a different part of the criminal code, which is 20.1. Sentencing provisions is in a separate part. So there's no obligation for the review board, which is that administrative tribunal I was talking to you about, that they had to take these individualized considerations into account for not criminally responsible or unfit accused. And in 2006, our Court of Appeal in Ontario rendered a decision saying that notwithstanding the fact that there's no obligation of the review board to take into consideration these what are now known as Gladue principles, that it's highly recommended for that to be done. So my PhD research focused on how the review board in Ontario was looking into these considerations and what kind of improvements could be made on the system.
Okay, so yeah, you've covered a lot of ground there, but actually, because the 2 areas I wanted to sort of pursue a little bit further was these Gladue principles and also mental health. So maybe just on the Gladue principles, how effective do you think those, I mean, in terms of how, you're telling the individual stories of hardship in people's lives linked to their Indigenous identity, and how effective have those been, really?
In 2018, Professors Sylvestre, who's the Dean of Civil Law at the University of Ottawa, and Denis Boileau did extensive research with regard to the use of Gladue principles in the criminal justice system. And they found that, unfortunately, the effect hadn't been as effective as they would have thought. So that sentencing judges weren't necessarily always considering their obligations under the sentencing provisions. And just for you to know, as Indigenous people, we're just under 6% of the Canadian population. And what is shocking is that the incarceration rates for the general population in Canada right now, 32% of the men are Indigenous and close to 50% are women. So there's a significant issue when you think we're less than 6% of the population, but looking at our women, 50% of incarcerated people in Canada are Indigenous women and 32% are men. So evidently, notwithstanding the fact that the government of Canada made amendments to the criminal code in 95-96, instead of seeing the numbers go down, and our court in 2012 in a decision called Ipili looked at the society issues regarding these amendments to see, and they made a strong comment that unfortunately we were hoping that these amendments would improve the plight of Indigenous people in the incarceration rates. The numbers keep going up. So the trajectory's not been overly good. What is the solution? I really can't say, but I have to say that it's not positive.
Yeah, and also, if you think of the Gladue principles coming in at the point of sentencing, one might want to think about all the other steps in the criminal justice process where the specificities of Indigenous people's lives may have an impact. Okay, can you just elaborate more on the mental health, your work on mental health? Because mental health is a huge domain of interest, and we have the Mental Health Commission of Canada, and even different definitions of, we think of mental illness, mental disability, psychiatric illnesses, then mental health, which affects all of us. So I'm just interested, what's your approach to mental health, and how have you?
Well, I'm really fortunate because I get a platform like this and at other institutions and places to talk about mental health. So it touches 50% of the people in this room are touched directly or indirectly by mental health issues. I think that there's been an evolution from even when I joined the Royal Ottawa Healthcare Group in 2009. I remember, for example, when I joined Canada Post, where you had managers who had employees that were often on sick leave because, for example, they were suffering from depression, and there were issues related to that, and the typical response would have been, well, take your medication and come to work. And it was not seen in a positive light when I started practicing, but I'm really thankful and hopeful because there has been much improvement about how we see mental health as a society, how we see it in the workplace. There has been an evolution to destigmatize mental health because the more we talk about it, the less people are going to feel afraid to come forward to discuss it with others. Mm-hmm. And a lot of time when I meet with groups, one of the things that I'll ask you to do when you leave here today is, I'm sure you know one person who's dealing with these types of issues, and I would really recommend that you reach out to them to just see how they're doing, because at times just asking someone how you're doing and you want to go out for a coffee and just get out of your regular routine is all that they need that day to feel a bit better. So I really urge everyone here to think about that one person you know and reach out to them when you leave today.
Okay, and I think you also did some specific work on mental health in the legal profession and even in the judiciary.
I did. So I had been asked when I was at the Royal by Chief Justice Heather Smith of the Superior Court in Ontario to create a manual for the Superior Court judges, and then I also did the same then for our provincial court. And the goal of creating this manual for them was to talk about, for example, the different mental health conditions under the DSM-5, which is the Bible of psychiatry, where there are symptoms, diagnoses, etc. So I worked on that with a psychiatrist, Dr. Mathieu Dufour, who's now actually, I think, in charge of forensics here at the Pinnell Institute. And we put together a manual for judges to know, okay, well, if someone is suffering from schizophrenia, what are the kind of medications will be reading about? Clozapine, these types of things. What are the impacts when they're taking these medications? So clozapine is known as the gold star for schizophrenia, for example. It's normally the last resort medication that a psychiatrist will administer to someone suffering from schizophrenia. And the judge now will know that normally you'll take a blood test once a month to make sure that their white global cells are at the right levels, etc. So, and it also gave information to how in Ontario, we have the Mental Health Act, the Healthcare Consent Act, the Substitute Decisions Act, how these three legislations work together, and how do provincial legislations also fit into what we have under Part 20.1 of the Criminal Code with the review boards, because people who are in forensic mental health care fall under the criminal code, but when it comes to medications, etc., community treatment orders, which we have in Ontario, you have to look at the provincial legislation. It's complex, so it was to provide basically a manual for them to look into. And I also did a lot of training through the NJI that I created documents. That's a National Judiciary Institute. It actually does a lot of training for judges throughout Canada. So I've helped them out with the creation of documents. And I speak at a series of different events and also to different lawyers, etc.
Yeah, it's really interesting. And it's also about ensuring that people take care of themselves. And the legal
Absolutely.
profession is, you know, there's a lot of stress, there's a lot of competition, there's a lot of long hours of work. And although you seem guilty of long hours of work, I have to say, but nevertheless, yeah, so that's, yeah, interesting. And just one final thing, given that it's really interesting to hear about your diverse work, prior, labor, some human rights, you mentioned administrative law. How have those been important for preparing you for the work at the court?
I've been fortunate because throughout my practice, it's very varied. So you don't see someone who normally has done labor employment finish in mental health. I always say I fell into mental health law because of the work that I had at the Royal, which was an exceptional practice to have these varied experiences. And I've litigated at all the different levels of court. I did a lot of administrative tribunal work on the mental health work, and also a lot of court of appeal work on specifically on forensic mental health. So it really helped me because as a litigator, you know the rules of evidence. Also at the different levels, there are different procedures, right. The rules of engagement for the different levels of tribunals and the court system. So I found that was very helpful, especially sitting as a trial judge, because you really need a good understanding of the rules of evidence and the law of evidence.
Right, process. And it's interesting that a lot of your work prior to being on the Supreme Court around Indigenous issues, well, the Gladue came partly through your academic journey, really. And
right.
So you pursued that interest particularly through your advanced studies, which is really interesting. Yeah.
And I was fortunate because I wanted to work in Aboriginal law, and I didn't get that position that I hoped for, but in a roundabout way, that's where I finished part of my career, was by focusing on this research on Gladue principles. So I was really fortunate to, although didn't start there, ended up by full circle and really finishing in one part of my practice in something that really was meaningful to me.
Okay, and I wanted to turn to, for the last part of our conversation, to your experience and your work and the significance of your appointment to the Supreme Court of Canada. And in some ways, it's challenging to be the first Indigenous justice at the Supreme Court of Canada. I remember years ago, Bertha Wilson, as the first woman judge, gave a famous speech at Osgood about that. And I'm just wondering, how has your experience been so far, and how have you dealt with the pressures and the expectations of assuming this important role?
I have to say, it's amazing. It's incredible to think that I never would have thought I would have finished at the Supreme Court of Canada when I was a kid. I just wanted to be a lawyer. So for this to happen is, for me, my family, my community, it's a proud moment. It's something that is humbling. And it just, I don't know, every day I go to work, and I remember the first day, the first year, every time I'd go to work, my assistant, we'd high five when I got in. It's like, hey, we made it, we're here. But it's not an easy journey when you're a first. At times it's heavy. There is a bit of imposter syndrome when you start, because you're in this new environment, there are expectations. There's some people that think you're the token Indigenous appointment because they don't look at your accomplishments. So it's a mix of feelings when you start, but the biggest feeling that does come out is the pride of being there and to represent my community, but also just varied Canadians, the Franco-Ontarians on our court. I think it's something that's really important. And for me, throughout my legal career, access to justice in French outside of Quebec has been very important. And one of the things I didn't talk about was the last year in the Superior Court of Justice, I was the local administrative judge responsible for the courthouse in L'Orignal, which is the Francophone courthouse in Ontario, the oldest one, built in 1824. And it serves the Francophone population of Eastern Ontario, and about 70% of our files were in French. So I was able to manage that courthouse. I sat there half of my time and half in Ottawa, and that was a really proud moment. So to be on, and another thing that I'm very proud of is that we're a fluently bilingual court where we feel free to speak in the language of our choice when we're in meetings. And I'm able to write cases in the language of my choice. And my choice is when I hear a case in English, I write it in English. But if I hear it in French, I write it in French.
Yeah, that's really interesting. That intersection of Indigenous and linguistic minority identity and gender even too.
We're a majority of women.
Okay, more generally, what are there any particularly or critical challenges that you believe the Canadian justice system is currently facing, or more specifically that the Supreme Court is facing, sort of in the years to come?
Well, our chief has talked about this, about misinformation and the traditional media that we used to see. So, for example, in our courtroom on the right, all the seating area was reserved for the traditional media that really aren't there anymore. And having access to justice is important, and to be properly informed about the justice system and what it means and what happens. And unfortunately, over the years, there's been some misinformation. And I think that's something that all the courts at the different levels are dealing with. And we have to be mindful of what you're reading on social media. Is it true? Is it not? Sometimes it's really important. We have what are called the cases in brief that our Chief Justice put into place. So at times I will recommend to the Canadian population, I know some of our decisions may be long and onerous to read, so just go and look at the cases in brief, because I think it's very important for the Canadian population to be well briefed and to understand exactly the decisions that we put out, because they are national decisions of national importance that touch a lot of different people for different reasons.
Yeah, it's interesting the role of the media in educating the public about the outcome of cases. And I know here at the law faculty we often get contacted by journalists to comment on and to help educate the public in that regard. This one, I just wanted to probe you a little bit more deeply into how, whether and to what extent your identity as an Indigenous Francophone woman impacts your approach to your judicial philosophy, or your approach to judging, or your approach to cases. That may be a bit hard to answer, but I don't know.
I don't think I have a philosophy per se because of my background. My background's unique, and I have a point of view as an Indigenous Francophone woman. So I think that as a woman, I bring something that may be different than a male colleague. Like my male colleague may bring a different perspective. I don't think that I render a decision and you'll be able to say, well, O'Bonsawin will always fall on the right or on the left, or I really wouldn't say that. I think that when I and my colleagues, we make a decision, it's based on how the case is presented before us. We all have our individual life experiences and backgrounds, and of course it informs how we see things, but I don't think that it pushes us in a direction that we're always going to follow that journey. I think that we have an obligation as independent judiciaries to render decision based on how it's been presented to us.
Okay, thank you. And just to sort of wrap up in terms of a final question from me, and then we'll open it up, so start thinking about what additional questions you'd like to ask. Is there any message that you'd like to leave with the audience about the role of law or justice in Canada today, or your trajectory in that?
Well, I have to say, one of the things I'll say is I'm proud in Canada that we have a strong independent judiciary. I think that it can't be said that when someone's named to one of our levels of the court, it's because that there's a specific connection with a government, etc., especially for the federal nomination process, because there is a judicial advisory panel that will look at the applications that come in, and this committee is independent, and they'll put forward a recommendation to the government, either someone who is not recommended, or highly recommended. And I think that that's something to be proud of as Canadians, to say that that nominations are made in an unbiased fashion. And I think there's been an evolution also, that a lot of our Canadian population is varied, and we're starting to see, as Canadians, ourselves reflected in the judges that have been appointed. So I think it's something very positive and something that Canadians should be proud of, and because I'm surely proud of it.
Okay, great. Thank you so much for answering that range of questions. And I want to... we have time, and I wanted to leave time for you to join into the conversation. And if there are specific questions, there are 2 microphones. If you could use the microphones, because some people are watching online. Questions?
I don't know if that's good or not. You're speechless.
You have to go to the microphone if you just, yeah.
And I'll just ask, could you say your name, please?
First name Harold.
Hi, Harold.
Family name Gravelsons. I'm wondering if you could speak a little bit to the Canadian Supreme Court's difference from the United States, or the impressions we have of Supreme Court justices there, specifically on the issue of other judges consulting you or wanting you to translate your life experience and how it applies to receiving and interpreting the legal facts of a case. In other words, other Supreme Court judges wanting you to educate them, and for you necessarily to have the capacity to translate for them.
Translate what exactly?
The point I'm trying to touch on is there's an idea that a diverse court will have members of diversity who will issue an opinion which reflects their own individual diverse experience. There's another view that would sort of say, well, the existing members of the court might well start to shift in how they handle their judgeships and how they render decisions, because now they have somebody that they will be consulting behind closed doors who is one of them, in the sense of being one of the 9.
Yeah, I don't know if I would say that there's a shifting, because even before I came, there were groundbreaking cases and different files in Indigenous issues, mental health issues, even labor issues before I arrived. So I think that as a court, we're 9, we consult, we have discussions. I think we at times feed off of each other's thoughts and opinions. Does it shift a court? I don't think so. I think it helps a court to be diversified and to have different opinions, but we're 9 people, and it's not one people that shifts 8 others. So I think that discussions are definitely had, and but we do work as a team of 9. We don't always agree. And I think that's the beauty of it. And there's also the geographic nominations, right? So 3 from Quebec, 3 from Ontario, 2 from out west and north, and 1 from the east. So we always bring different considerations. It could be geographic, it could be language, it could be ethnic. But at the end of the day, I think it's not one person that convinces everyone else, but it does add a different perspective.
Thank you.
Thank you for your question.
I think there's a question at the microphone here.
Hi.
You can introduce yourself.
Yeah, my name is Renaud.
Hello,
I had a
Renaud.
question about your work in mental health and how it relates to your position as a Supreme Court Justice. Addiction is now classified as a mental disorder, I think in
Sorry, what?
Addiction is now
Yes.
classified as a mental disorder, I think in the DSM-5.
Right.
Despite this, people suffering from this are way, way overrepresented in our prisons, where the underlying issue of addiction is rarely addressed. Do you think, as a Supreme Court Justice, you can have a role in addressing this issue? And if so, how would you go about it?
So I don't think I have a role to address a societal issue like that. I think that these are issues to be dealt with as a society, but I think that we do have at the trial levels in the provincial courts, for example, I'll speak about my knowledge in Ontario, where we have a specialized mental health court, and there's also an addictions court, there's a First People's Court, and I think that these specialized courts are uniquely placed because they are specialists in the different issues, and they have a good understanding of the issues. As a trial judge, for example, when I sentence someone, at the Royal Ottawa Healthcare Group, we used to provide the mental health services through our Brockville Mental Health Center to St. Lawrence Valley Correctional, which is a provincially run institution of a sentence of 2 years less a day. They would go there. So as a trial judge, I would be able then to impose a sentence if I did do it at 2 years less a day. And I would be able to recommend that the person be admitted there because they, for example, were dealing with a significant mental health issue. But as a judge, I could make a recommendation, but I can't impose it because that's an institutional question. So I guess I myself can't do any significant changes, but I think it's important, though, with my expertise in mental health law, that I could talk about the impacts and hopefully how we can improve this issue by talking about it and destigmatizing it and including the different addictions to drugs to also alcohol.
Thank you.
Go ahead.
Hi, my name's Arthur.
Hi, Arthur.
So we talked a little bit earlier about how there were shortcomings with the Gladue principles compared to what we had hoped they would bring in the 90s following the Supreme Court decision and the amendment of the criminal code. How would you like those principles to be applied to the rest of the criminal justice system outside of sentencing? I think you talked about tribunals dealing, for example, with people who are unfit for trial. How would you want those considerations to come into play outside of just the sentencing part of the criminal justice system? And how do you think they would affect positively?
So I can't say how I want them because as in the position that I have is not really, I'm not well placed to do that. But I could tell you how they have been treated. So they've been treated in the mental health context. In Quebec here, for example, before our court issued the C-92 decision with regard to whether or not Indigenous communities had the right to self-govern child protection, for example, a lot of the Quebec courts were looking at Gladue principles and how those could work in child protection. So I know that we also used to do it in bails. So when I used to sit in Superior Court as a bail judge, even before the amendments, because I think the criminal code was amended maybe 3 or 4 years ago to add that consideration for bail court under 515, I think it is. That was something that I would consider. And I remember there was a man who had appeared in front of me and I recognized his name as an Indigenous name. And I asked him, I said, have you talked to a lawyer with regard to your indigeneity? And is it something that you want to bring forward? And he said, yes, but I'm not represented. So I had asked that he meet with duty counsel for duty counsel to explain to him Gladue principles, how it worked and how that could apply to him. So that was at the trial level. So I think that it has been applied in different contexts, and I think that there's always a benefit for us to consider the individual background of an Indigenous person and why they are where they are today. And one of the things I do want to note, though, is some people think it's, you might have heard a get out of jail free card, and it really is not. It's a consideration. It doesn't mean that the sentence will be varied. It could be the same, but it is still a consideration that has to be taken into account.
Thank you.
Thank you. I think we'll have a second question from this microphone because I know you were waiting there.
Thank you. I'm Jennifer, and thank you so much for
Jennifer.
your time and your insight today. So I had a question just about like Indigenous reconciliation and self-governance. I guess like we have some law students here, and what advice would you give to law students who are maybe interested in like Aboriginal law or pushing towards more meaningful sort of like Indigenous reconciliation, self-governance? So there's like a lot of different takes, and it's just like I'm in 1L, and I'm like, oh, I'm at like sort of the beginning of this journey, and I'm just really curious about what your perspective is and what different perspectives are on like meaningful work that could be done by people who are in sort of my position or people who are in the position of like future jurists.
One of the things that I always recommend to everyone, it's not only someone who has an interest in Indigenous issues, just as a Canadian population, is I've always recommended that everyone should read at least as a minimum the executive summary of the Truth and Reconciliation Commission of Canada. I know the report was 5 volumes. Some might find that long. That's why I always say, and when my sons were teenagers, we went through it. I think it's important for everyone to get an understanding and what are the 94 calls to action. For example, in Quebec, there's the Viens Commission, which came out, I think, maybe 4 years ago, also had really important recommendations that came out of that. So I think that's a starting point. A lot of times I'll recommend people should just go into our Indigenous communities, attend friendship centers, go to powwows, because unfortunately at times people want to go into a community and just want to say, okay, well, what do I do? And at times it's to go in and to listen, not to say I want, but to listen actively and just to learn about what their culture is, what the traditions are. And by learning these things, I think you get a better appreciation. And then by working more hand in hand, you get to offer services and work with the community and be a team member, basically. And for me, that is the evolution of reconciliation. And it really starts by, 1, informing yourself, and 2, going into the different communities and learning about them.
Thank you so much.
Thanks.
Okay, and there's a question here.
I would just like to add, you may want to read Murray Sinclair's book, Who We Are.
It is amazing.
It's a very enlightening.
It's very good.
The 2 parts. You may also want to read books by Marie Baptiste. And that's actually going to be part of the question here. So I'm going to come at it quite differently. I have to tell you.
Sorry, so what's your name?
My name is Willie Fournier. I'm a Francescois originally, but it was a long time back, so that's a Francophone from Saskatchewan originally, but I've been in Montreal. But I do have a long experience with First Nations. So when I was 19, I opened a school in northwestern Saskatchewan in a brand new community of Dene and Cree people. And just to give you an idea what things are like living in a community like that, we had no running water, no electricity, and we never had a single piece of written material until February. We improvised. I had 44 kids in grade 1, 4 to 17, and Ed had 26 from grade, and we never had one piece of written material unless we went south to Buffalo Narrows or we went around and up to La Loche. I was a special student in law here about 10 years ago. I've worked incidentally with First Nations for over 30 years, after a career overseeing 132 collective agreements, during which time I was approached to replace...
So see, you know what I'm talking about.
Yes, I was approached to replace John Perry at Canada Post as the head of HR there. I'm interested in how people from different cultures experience justice. And I'm very interested also in the aspect of language. So speaking of Marie Baptiste, in the book she wrote with Saive, Youngblood Henderson, she talks about the illusion of benign translatability, the idea that we can take any language and translate it and basically say the same thing in English or French. It's simply not true. The root of the word decide in English, de from, sedari, to cut or separate. I can decide all by myself. The root of that word in all Sanskrit languages and scheiden in German is to cut or separate. I know a little more Mi'kmaq than I do the other languages. And when you ask elders in Mi'kmaq, what's your word for decide? Il sudahan. So I asked them, it literally means to decide. She says, yes, it means we came to an agreement. That's very different. You read the great law. Well, let's talk about Anishinaabe. Anishinaabe sit in circles to have equality and things like that. You read the great law, there's nothing about circles. That's the Haudenosaunee, the Mohawks, etc. We sit across and opposite. We come from different minds to one good mind. I'm interested in how Indigenous people, with languages that are largely metaphorically based and verb-based, how can they experience more of a sense of justice, and also with the importance of story in Indigenous, how in our legal systems can they actually have a better experience of justice going forward?
Yeah, I think and that has to be part of reconciliation. It's part of working together. And one of the best systems, I have to say, is the Federal Court of Canada. They have a specific working group now headed by Justice Paul Favel from Saskatchewan, Poundmaker. And they really are advanced in their thinking. So they have smudging, they have a lot of our different levels of courts have eagle feathers. So for example, when I was sworn in to the Superior Court, we had just received an eagle feather from Claudette Commanda, an elder who I had actually went to law school with. So it was quite amazing to be sworn in on an eagle feather, and I had asked the same thing at the Supreme Court, and I'm now the holder of our eagle feather that was gifted to me by Gilles de White Duck, an elder from Gideon Zibi. And I think that we all have a role to play, and what I thought was really special in our Superior Court was the eagle holder was an Allochthon, a non-Indigenous person, and she received teachings from Claudette, who had handed her the eagle feather, because there's an obligation. So it's not like you get an eagle feather and you put it in a desk drawer. There are traditions, and I myself have my eagle feather that I inherited for our court, so I'm the holder for the court, and I've named her Jacqueline after my grandmother. And I feed her by smudging with her, etc. So I think that for the court system, we have to evolve in our thinking. I think that there are the calls to justice under the Truth and Reconciliation Commission of Canada. I think that a lot of the law schools are working actively about adding Indigenous teachings in the first year. Some of them, it's an obligatory component, which is definitely something positive. I think in our high schools, we're getting more teachings, because when we went to school, it was not the teachings that my kids, when they were in high school, have started to learn about the impact of the different residential schools, intergenerational trauma, etc. So I think that education is the key. And I think an active involvement at the different players at different levels is important, not just as Indigenous people, but non-Indigenous people. And I think it's a part of a partnership. And I think it's the evolution towards reconciliation, because a lot of people say reconciliation, but it's not a catchword. It really means something. And for me, reconciliation means working together as an improvement as a society, and it's not just one-sided.
Okay, interesting. And it's interesting if you think of I know at the history of our law school, where we had the civil law tradition, then the common law with the national program, and now we have the McGill program. Increasingly, we do have a first-year class where it engages as well with Indigenous concepts of law through, there's also courses on Canadian state law about Indigenous rights, but Indigenous law. Have you seen any of those arguments coming before the court that engage with Indigenous law principles?
Well, we saw them in Bristol, we saw them on the C-92 case, so there are arguments definitely that do come forward, absolutely.
Yeah, which is interesting. And that where you have the translation issue, in terms of you have the French, English, and then there's such a diversity of Indigenous.
There was a lot of that in the Bristol case in front of us. There was a lot of the...
Can you just explain that case a little bit to the audience?
Oh, so the Bristol stems out of Northern Ontario, and it was with regard to the government's breach of treaties. And what did that mean, and what was the impact on the generations past and present and future? And it's something extremely significant. It came out last year.
Okay, interesting. Okay, are there any other questions that anyone wants to ask? This is your last chance. Don't be shy.
I'll just give you an example. So in my community, at times I'm asked, what did the laws look like? And one of the teachings that I received was with regard to, in the past, when there was an issue with regards to a decision that had to be made, we had long houses. And there was the circle of the women, the long house with the circle of the men, and one of the elders. And when it was time to make a decision, there'd be the representation from each longhouse that would come out, so the men and the women, and they would make a decision. If there was a disagreement and they couldn't resolve the matter, then it went to the longhouse of the elders, and the elder would, their group would make the final decision.
Interesting. Sounds like a good idea. Okay, so I think I'll turn it over to, maybe you can introduce it to, okay.
So thank you very much.
Yeah.
Merci beaucoup.
Thank you all very much. It's great to have you both the people on video, and I don't know if you realize, Michelle, but there's a vast more number of people watching you on video, and will be watching you in the future as well as the people here. So it's very exciting. But I'm going to be very rude and ask you one question myself, please, and then I'll get to the thank yous.
Go ahead.
But I'm wondering what makes people tick. Pardon me? I'm not...
Yourself.
Oh, sorry. Oh, I'm Don Walcott. I'm the past chair of the Friends of the Library, and unfortunately, Dr. Baudry could not come tonight, and so I have been asked to step in. So I have always said the thank yous and farewells, so I'm saying the thank yous and farewells again tonight. But I just thought, I've been sitting here saying, I just wonder what makes people tick, and what makes you tick. And I have a niece who works in the Supreme Court in BC. She talks about some judges love to write, you know, when they write fantastic opinions. Other people like the process of sitting in the court. Other people like, I guess, the discussions. I wave my hands. I'm sorry, I'm a bit French too.
So you were French.
Yes, I am. My grandfather. And so I was just curious, what makes you tick? What turns you on? What gives you joy in your job?
Many things. I love hearing people's stories. I love the rule of law and the mix. When you think our court were 9 members, we didn't know many of each other before we got there, and I find that it's stimulating to work with these brilliant jurists and to have an exchange of ideas. We don't always agree, but that's okay. We're always respectful to each other's points of view. And I think that for me, it's amazing to think that our decisions touch Canadians throughout Canada. The other thing that makes me tick are events like this. I actually enjoy speaking at events, talking to people, meeting Canadians, demystifying what we do in our court, because I think it's important. A lot of people don't understand what the Supreme Court of Canada does, how it works, and if I could be part of demystifying and talking about the work that we do, which is one of the mandates that our Chief Justice is very open and encouraging about, and right now he and my colleagues, Justice Karakazanis and Justice Cassira, are actually in Victoria as part of our 150th anniversary, talking about the work and going into the communities. And for me, going into communities is an amazing part of this job that I have. So I sit with brilliant people on a daily basis, which is extremely stimulating. but I also get to go out in the communities and meet people, which is also something that I enjoy to do.
Thank you so much. I really do appreciate it. Thank you. That's very kind of you. And so again, I will read, this is Guylain's speech, so I'm just reading it. But I want to thank you all for being here this evening, as I said, both physically here and on the video. It has been a great privilege to hear the Honourable Justice Michelle O'Bonsawin share such thoughtful insights, and I do thought they were very thoughtful, weren't they? I thought it was really interesting. I do make comments, as I make speeches too, on topics of profound importance to us all. Justice O'Bonsawin, your reflections tonight have been both enlightening and inspiring. Thank you for joining 4 other Supreme Court Justices, Chief Justice Richard Wagner, Rosalie Abella, Ian Binney, and Morris Fish, who have also all honored us by giving this lecture. So you are now the 5th. Terrific. I would also like to extend a heartfelt thank you to Professor Colleen Shepherd for graciously stepping in as our moderator. Your expertise and skill in guiding the discussion have greatly enriched this event. We are truly grateful to you, and in recognition of this, we have small tokens of appreciation to give to both of you.
The formal...
I still have more to go, sorry. I go on and on, sorry. I would also like to acknowledge our esteemed friend and former Dean of the Faculty of Law, Robert Leckie, whose ongoing support of this lecture series, and has been a long time support. It's deeply appreciated. And our new friend, Interim Dean Piper. A sincere thank you goes to Lenore Harris, Stephanie Taylor, and the Executive Committee of the Friends of the McGill Library, whose steadfast commitment over the past 35 years continues to strengthen the libraries and foster vibrant gatherings such as this one. Finally, my warm thanks go to the library's events team and our colleagues from University Advancement and Multimedia. Those are the guys that are running around, and they have not failed us in all the lectures we've ever had. So I really am saying thank you very much indeed. Again, thank you all very much for joining us, and we look forward to welcome you to future events. Safe travels and good evening. Thank you.